pretty much anyone who owns real estate in the state of Washington that has trees could potentially be a plaintiff in a timber trespass action. Or if anyone who whether intentionally or unintentionally harms someone else's trees could ultimately be a defendant in a timber trespass action. The cases really are somewhat straightforward. There's not a lot of complexity in the issues, but they're interesting because they can be very highly emotionally charged. They typically are cases that involve neighbors and people who know each other. And they typically involve a plaintiff who feels like the sanctity of their home has been violated by someone who came onto their property and, intentionally cut down a tree and imposed their will on, the landowner's property. And, people here in Washington and across the United States have strong feelings about their property rights. So it does generate some emotionally charged litigation. So at the beginning, I just want to show you where we're going to go. I'm going to give you a brief overview of the statutory language that applies in the timber trespass context. And then we're going to talk about some of the common issues that pop up in timber trespass litigation. Along the way, I'm going to discuss several of the leading cases analyzing and applying the timber trespass statute over the last several years in Washington state. And this presentation will have citations to those cases, so you can look them up yourself if you would like. So as an introduction here, the timber trespass statute is found at RCW 6412030. That is the main provision. And that section provides a cause of action for a landowner against someone who has cut down, removed, injured, or carried away the person's tree, the plaintiff's tree or shrub, and it provides treble damages. Now, treble damages just means that the court will award 3 times the actual damages incurred. So if the value of the trees was $1,000, the award would be $3,000. Or if it was $10,000, the award with trebling would be $30,000. So that provides a lot of incentive for plaintiffs to be able to vindicate their rights under the timber trespass statute. The courts have described, several courts have described the purpose, the legislative purpose behind the Timber Trespass Act. First, focusing on why there's treble damages. They've discussed that the treble damages has a couple purposes, but one of them is that they provide a rough measure of future damages. So when your tree is removed against your will, let's say you have a home with, a hedge that acts as a privacy screen that you really value, and it is completely removed. It may be years before, even if you replant, it may be years before you get back your property to its prior state. So the treble damages in part compensates for that future time where you're going to be, suffering through waiting for your property to get back to where it was. There is also a punitive aspect to the treble damages, and therefore the courts have recognized that part of the intent is to punish voluntary offenders. I cited 2 of the leading cases down at the bottom here on this slide, and the Pendergrass decision from the Court of Appeals in 2015 explained that the Timber Trespass Action statute is intended to discourage persons from carelessly or intentionally removing another's merchantable shrubs or trees on the gamble that the enterprise will be profitable if actual damages only are incurred. And then the the court in the Happy Bunch case, also cited down at the bottom, recognized that the timber trespass is a legislative legislative announcement that there shall be no self-created right of eminent domain. And when I think of those two purposes, what really comes to mind is the adage that you hear sometimes: better to ask for forgiveness than ask for permission. And really, the legislature is repudiating that adage when it comes to harming someone else's tree. The legislature definitely does not want neighbors to be taking, self-help and exercising a self-created right of eminent domain with the idea that it will be, better for them simply to ask forgiveness after they do that. And therefore, that is part of why there is a treble damages component to the Timber Trespass Act. So I'd like to look at the actual text of the Timber Trespass Statute. And before doing that, I want to note that it's interesting that Washington actually has two statutes currently on its books that refer to the removal of trees. Over the past years, it has resulted in some confusion and some creative lawyering where people tried to shoehorn timber trespass claims into the Waste Statute, which is RCW 424-630. However, a recent decision from the Washington Supreme Court has really put an end to that, or should have put an end to that. So first, let's focus on the text of the Timber Trespass Statute, RCW 64-12-030. So I'm not going to read the whole text, but focusing in on the key elements, the statute provides that whenever any person shall cut down, girdle, otherwise injure, or carry off any tree on the land of another person without legal or lawful authority, then any judgment against the plaintiff in a timber trespass action shall be for treble the amount of the damages claimed or assessed. So looking back at the first sentence, cut down, girdle, otherwise injure, or carry off, I just want to point out that a typical timber trespass action does often involve trees that are actually cut down and completely removed or down to the stump. So that is, an easy example, but that is not all that the timber trespass statute prohibits or applies to. So girdling is an act that I have never seen in an actual case, but it is an act where the tree is not actually cut down, but it is injured and ultimately will die. And then there's a catch-all, otherwise injure a tree. So if a tree is not completely cut down, but it is cut back in such a way that it's injured the viability of the tree, that is also going to be a violation of the timber trespass statute. And then finally, even if you didn't cut down the tree, but let's say someone else cut down their own tree, and then you came on their property and carried it off and maybe went and sold the timber to a timber processor, that act of carrying the tree off would also violate the Timber Trespass Act if it's done without lawful authority. So the key that I want to point out here before we move on to the next statute is that there is no attorney's fees provision in the Timber Trespass Statute. In Washington and in the United States in general, courts are going to not award attorney's fees or shift the costs of attorney's fees to the other party unless there's a contract that provides that or a statute that applies and provides for fee shifting. So the Timber Trespass Statute, while it does provide a lot of leverage through its treble damages provision, it does not include an attorney's fees award. And that is why there has been a number of cases where timber trespass claims are shoehorned into the Waste Statute. So the Waste Statute here, the text of it, it's RCW 424-630, And it is much broader than the timber trespass statute. It involves damage to land, injury to land, or improvements to land. But if we focus on the first line under subsection 1, it's clear that it is duplicative of the timber trespass statute in one respect. So it starts, every person who goes onto the land of another and who removes timber is liable to the injured party for treble the amount of damages caused by the removal. So that language really is duplicative of some of the language in the timber trespass statute, and it provides the same treble damage award. However, if you look down at the end of the first paragraph, the Waste Statute also provides, in addition, the person is liable for reimbursing the injured party for the party's reasonable costs, including but not limited to investigative costs and reasonable attorney's fees and other litigation related costs. So that is why some attorneys have tried to get creative and shoehorn a timber trespass claim into the Waste Statute. I mean, it didn't require a whole lot of creativity because the plain text of it refers to the removal of timber. However, if we look down to the second paragraph where I've highlighted it, the Waste Statute specifically states this section does not apply in any case where liability for damages is provided under RCW 64-12-030 and various other statutes. So that 64-12-030 reference is a reference to the timber trespass statute. So when there is liability for damages under the timber trespass statute, that same liability and damages would not be recoverable under the Waste Statute. And the case where the Washington Supreme Court recently made that clear is Porter v. Kirkendall, which I've cited down at the bottom. So before we go on from the Waste Statute, I do want to mention that if you have a timber trespass claim, you shouldn't automatically move past the Waste Statute, because oftentimes when there is a timber trespass, there very well could also be separate conduct or related but different conduct that triggers liability under the Waste Statute. For example, if there is a timber trespass that involves heavy construction equipment that is brought on their property, and that equipment damages the actual land or any of the structures on that land, that could potentially trigger liability under the Waste Statute. And therefore, when I speak with potential plaintiffs, people who call me to figure out if they have a potential timber trespass claim, I always ask them about the broader situation and what has happened, and try to figure out if there is a waste claim that could be asserted alongside the timber trespass claim, and therefore take advantage of the fee shifting provision in the Waste Statute. Now, it's already a little bit confusing with two separate statutes specifically addressing the removal of timber, but that is not everything we have to think about when there is a harm to a tree, because not every cutting of another person's tree results in a timber trespass. And there is case law in Washington on common law nuisance, where it's held that a property owner has the right to trim branches that extend onto his or her property. And therefore, when discussing a potential claim, I get a lot of calls from people who basically had a tree cut down or trimmed by a neighbor, and they've essentially Googled, what do I do when someone cuts my tree? And they end up calling me to explore what their rights are. And sometimes it's as simple as, the other person cut a tree that was, hanging over the fence line, or cut a branch that was hanging over the fence line. And so you need to look at the facts about was one of those elements of the Timber Trespass Act triggered. The tree was cut down, it was girdled, it was otherwise injured, or it was carried away? Or was it merely a trimming of the branches to abate a nuisance that could be lawful under Washington's common law nuisance law? I wanted to point out here the Happy Bunch case, because that case is actually a very interesting case for a number of reasons involving the Timber Trespass Act. But it makes clear that you know, the common law right to trim branches that extend over a property line is definitely tempered by the Timber Trespass Act. So in Happy Bunch, the defendant removed a number of trees that sat directly on the property line. And the court, in the excerpt that I have quoted down here, explains that when a tree is standing directly on the property line, such that the property line cuts through the stump of the tree, that the tree is considered the common property of both parties. And even though, you know, the potential defendant is a, you know, owner in common of that tree, a timber trespass claim will still lie against that common owner in common if he or she cuts down or destroys the tree without the consent of the other. So, so you really need to look at the situation from all perspectives. You know, does it violate? Did the action being complained of violate one of the elements of the Timber Trespass Act? Is it you know, something that is governed by common law nuisance law before you start a timber trespass claim? So once you have a timber trespass action, I want to discuss basically what are the key common issues that come up. And really, the issues are fairly straightforward, and you can really get them by following the elements of the statute that we already went through. But I want to talk about a few of them and maybe give examples of how really they are straightforward. So the first element is the tree that was cut or injured has to be a tree on the plaintiff's land. So that will be an issue in the case, and it sometimes it isn't really an issue because it's conceded. Sometimes there's a survey done beforehand, and the survey shows where the property line is in relation to the tree, and gives evidence of who owns the tree. But sometimes it will be contested, and in that case, the parties may get, you know, competing surveyors, and part of the action can be a battle of witnesses, or of expert witnesses. And actually, there's two different times when battle of experts can come into play in timber trespass claims. But the first one is, where's the tree? It can be, in some cases, resolved simply through the testimony of the parties, but it may require more, and the retention of expert witnesses to do a survey and establish where the trees were located. The next question is, were the trees that were removed or injured done so with lawful authority? Because if there was lawful authority, then it is not going to be a violation of the statute. And what this really comes down to is, was there permission? And sometimes this isn't an issue, but when it is, it really turns into a credibility contest. And if there comes to be a credibility contest, it's really going to be an issue that ultimately has to be resolved at trial, where the trier of fact can, you know, weigh the competing parties' testimony and decide who is giving the more reliable testimony. There's also an issue with when permission was given but exceeded. For example, there can be a case where neighbors agree that, you know, the defendant, the ultimate defendant, is authorized to take down a tree. Maybe there's a tree that's right on the property line and they agree to take it down. But then when that neighbor ends up doing the work, he ends up taking down 2 or 3 other trees right around the same area. And that can be another credibility issue, another disputed issue of fact that has to be resolved at trial. It can also be an issue that we'll get to later, where the plaintiff or the defendant can look and point at the permission or the exceeded permission as a mitigating factor when it comes time to assess the damages. The next issue is really the biggest issue. Was there a tree that was cut down, girdled, injured, or carried away? This issue, in my cases, really hasn't been much of an issue, because if a tree is cut down, it's usually fairly obvious and not disputed. I mean, usually there's a stump there and you can physically see that the tree was cut, and usually the disputed issues lie somewhere else other than whether it was actually cut down or not. However, one issue that arises relating to did the defendant cut down the tree is when the homeowner or the property owner retains someone else to do the work. So a property owner hires a contractor, a landscaper, or a arborist, or whoever to cut down the tree for them. At times, I've had cases where the defendant, the homeowner defendant, says, I shouldn't have any liability because I didn't do the work. It was, the contractor's violation. But from a planning perspective, at the outset of a case, you need to discuss this with the client to understand who did cut down the tree, who else was involved, and should there be one defendant, the property owner, or should there be multiple defendants, including the property owner and someone who cut down the tree on the property owner's behalf. Then we come to really what I see usually as the biggest issue, and that is damages. And damages in a timber trespass claim can be both economic and non-economic. And I want to talk first about the economic damages. So the timber trespass statute talks about, the damage, the actual damages from the removal or injury of the tree. This oftentimes comes down to a battle of experts. Both sides will retain an expert such as someone qualified to give appraisals of trees, and they will give an appraisal of what the value of the tree was. So it can be, a disputed issue with 2 experts both offering differing opinions regarding their expert opinions regarding the value of the tree. When they do this, there's several different theories that can be used for how to value the tree. One of them is the stumpage value, and that is commonly argued by defendants, probably because it is going to result in a lower value. But the stumpage value is essentially the value that a timber purchaser would pay a landowner for the tree, the value of the wood that they're going to use for timber purposes. But the case law discusses that if the stumpage value isn't adequate, if other appropriate valuation methods would place a higher fair market value on the trees, then you need to look to other methods. So 2 of the most common are lost profits and replacement costs. So the courts have found that in instances where the trees are Christmas trees, a Christmas tree farm, or fruit-bearing trees, something that is going to bear fruit that is then going to be sold over, the coming years, that lost profits would be the more appropriate way to value the lost trees. Same thing though, you can get an expert witness to give an opinion on what the lost profits are for the loss of the tree. And then finally, one that I think is more common because a lot of these involve residential properties is replacement costs. So the courts have found that the proper way to value the loss of residential, or sometimes they're called ornamental trees, is the cost to either replace or restore the lost or injured tree. And so the expert will do an appraisal assessment, very much like a real estate appraisal where they are doing reproduction costs, and they will assess what it would cost to bring that property from a tree perspective back to where it was before the injury. Now, I wanted to, before I talk about diminished land value, I wanted to discuss Happy Bunch again, because Happy Bunch, as I previously mentioned, talks about what happens when the trees are on the boundary line. And there's several questions. One was, can there be a timber trespass when the trees are on the boundary line and they're commonly owned by both neighbors? And there can. But the next question was, well, how do you value or how do you award damages when the tree is owned commonly by the two parties? And in the Happy Bunch case, the court found that you would do the same assessment for replacement costs of the tree, but then you would need to calculate what percentage of the tree's stump went into the ground on the plaintiff's side of the property line. And that percentage is the percentage that they would be able to recover of the total damages. So just as an example, if there's, a replacement cost of $1,000 and let's say $70 or $100, and 75% of the stump is on the plaintiff's side, the plaintiff would ultimately recover $75 for his or her share of the tree that's on their property, and then that amount would be trebled. The last valuation approach that I wanted to talk about is diminished value of land. There is case law in Washington that this is at times an appropriate valuation method. It's not very common, and it is really looked at for situations where simply awarding damages under one of the other theories, such as replacement costs, simply wouldn't do justice. It wouldn't make the plaintiff whole because in a situation where the timber trespass really harmed the value of the land, then you can look to the diminished value of the land as a potential method of calculating damages. And then finally, I wanted to talk about non-economic damages, and this is really emotional distress damages. So the timber trespass claim or statute, it talks about the damages that flow from the timber trespass. It doesn't specify, it doesn't limit that to the lost value of the tree itself. And the courts have made clear that all damages that flow from the timber trespass can be recovered and are subject to trebling. And the leading case on emotional distress damages in the timber trespass context is the Pendergrass case from the Court of Appeals 2015. In that case, the damages to the tree were only a couple $1,000s, but the court ended up awarding $40,000 in emotional distress damages, which then got trebled up to $120,000, I believe. So it can be a significant impact or a significant component of the damages award, and it can even be a much larger component than the replacement cost of the trees in the right situation. So the court in Pendergrass found that emotional distress is recoverable under the Timber Trespass Act, and it is also subject to the trebling of the damages award. And then finally, it also found that an emotional distress claim can be established simply by the testimony of the plaintiff, discussing and providing testimony of emotional impact that they have suffered from the loss of the trees. I want to now focus on a couple considerations that defendants should be thinking about when they have when they are facing a timber trespass action. The first one is mitigation. So RCW 6412-040 establishes a basis for mitigation of damages, and essentially what it does is, if it's satisfied, it makes the damages award only single damages instead of the treble damages. However, to prove mitigation or establish that only single damages are warranted, it is the defendant's burden to prove that the timber trespass was casual and involuntary, or that they acted with probable cause that the defendant owned the land. So the key is, it's the defendant's burden to establish it. The default under the statute is treble damages. And if the defendant wants to get out of treble damages, they're going to have to establish with competent evidence that the timber trespass was casual or involuntary, or that they acted with probable cause. Now, this could result in another, he said, she said type factual dispute. The court in Happy Bunch explained, however, that a mere subjective belief in the right to cutting trees is not sufficient for mitigation purposes pursuant to RCW 6412-040. On the contrary, where a person has been given notice that another has an ownership interest in trees and the person nonetheless cuts them down, the actor will be liable for treble damages under RCW 6412-030. And the Happy Bunch case was a case where there had been a survey before the trees were cut down, and that survey showed that the trees were either on the boundary line or were on the plaintiff's property. And therefore, the defendant was on notice that the plaintiff had an ownership interest in the trees, and they should not have cut them down without getting consent. I also wanted to touch again on the exceeded permission concept that we discussed earlier. There is some case law in Washington that when you have permission to cut down trees, but you exceed that permission, that could be a factor that can be looked at to try to prove that the timber trespass was involuntary or casual. But again, that is going to be the defendant's burden to establish that. The next issues for the defendant to consider are whether there should be other defendants. So as I discussed earlier, the two main candidates to be a defendant are the property owner or a contractor. And in a lot of cases where a property owner is sued for a timber trespass violation, they end up arguing and trying to push all the liability to the contractor who did the actual work, who actually removed the trees. In the Porter case cited here, the Supreme Court, however, found that both can be directly liable, that the claim against the property owner who merely retained the contractor isn't just a vicarious liability claim. It is a direct liability claim. There is direct liability for retaining someone else to do the timber trespass on your own behalf. So if you are named as a defendant, perhaps as a contractor, but you were hired to do the work, you should consider whether you should be asserting a claim against the person who retained you. Or if you are the homeowner, you should consider whether you should bring in the contractor. And then the last issue I wanted to talk about for the defendant's consideration is contribution. So the Porter v. Kirkendall case actually is a somewhat complex case in its discussion, but what it ultimately concludes, and it's a case where there was a property owner who retained a contractor to cut the property or cut the trees on the property, and the allegation was that they cut trees that extended past the property line onto the plaintiff's property. And the plaintiff ended up settling with the logging company and then proceeding in the case against the landowner. And the logging company assigned its contribution claim to the plaintiff. So the plaintiff was essentially trying to assert its the logging company's contribution claim against the neighboring landowner. So the Supreme Court observed that the Tort Reform Act does not allow a indemnity claim, a common law indemnity claim, when the act complained of is an intentional tort, and the lower court had found that a timber trespass claim was an intentional tort. And what the Supreme Court eventually found is that no, the timber trespass claim statute establishes strict liability. It's a strict liability tort. It doesn't matter that you were acting negligently. It doesn't matter that it was an accident. If you injure or cut down someone else's tree, you are going to be liable under the act. And arguments regarding negligence or accident only go to the proper measure of damages. And therefore, because it is a strict liability tort, contribution is allowed under the Tort Reform Act. So that's really the key thing that came out of that part of the Kirkendall decision, that defendants can seek contribution under the Tort Reform Act because the timber trespass case or claim is a strict liability claim. Now, the last thing I want to talk about here before we wrap up is the idea of insurance coverage. When a defendant has when a homeowner has a timber trespass claim brought against them, they should definitely put their homeowner's insurer on notice of the claim, because timber trespass claims are often covered under homeowners' policies. However, the insurer will almost certainly take the position that the treble damages are excluded from coverage. But it is important to keep this in mind. If there is coverage, you should put them on notice, and it could end up resulting in the carrier at minimum paying the cost of defense, and also contributing to the damages award, at least to the extent of the single damages. That is everything that I wanted to talk about today for the Timber Trespass Act. Thank you for joining us. If you have any questions about the Timber Trespass Act, I would be happy to talk to you. You can email me any questions at toddc@beresfordlaw.com, or you can give me a call at 425-776-4100. Thanks a lot for attending today.